Hey folks, this is one of two screencasts I'm going to do. This one will cover the multiple choice and true-false questions, and then we'll do a second one for the short answers. You guys all did pretty well on this. I hope that you learned something that you didn't even know. Let's get to it. Question one. According to our textbook, roughly how many cases are filed in the U.S. each year? It's the first sentence of the textbook. It's 100 million. A lot of cases. It's true that roughly 97% of cases settle before trial, but that's not the answer to the question that's asked. So make sure that you read the question and put down the best answer that responds to the actual question. Question two, how does jurisdiction usually differ between a first level appellate court and a second level appellate court? Remember that at the second level appellate, the answer is B. Second level appellate courts like the Supreme Court or like state Supreme Courts like the Supreme Judicial Court in Massachusetts, they tend to have discretionary jurisdiction. That means that they don't have to hear every case that people ask them to hear. And that's simply because it's a big important court, and you don't want to waste their time with cases that are not important or that are not likely to result in a different decision. The Supreme Court gets 8,000 cases a year to hear from, and if they could, they would probably get a lot more. So it's important that they have discretion to turn down cases. First level appellate courts, like state courts of appeal, they tend to have mandatory jurisdiction. That means that if you lose the trial court, you almost automatically get the right to appeal and to be heard on appeal. Basically, the rule is you get one appeal. You get one automatic appeal, and then you have to ask for permission to appeal to the next level. Question three, the environmental perspective. The answer is C. The environmental perspective describes kind of what's going on in the social and political environment around the judiciary and how that might affect judges. One example of that might be when you start seeing things in popular media, on TV, in sitcoms, in the theater, that shifts the kind of social dynamic in the country. That may create certain, not pressures so much, but it changes the way that judges view things. I mean, if you have a character in a popular sitcom confronting an issue like same-sex marriage or interracial marriage or gun rights even, it really doesn't matter. But these things, they kind of shift the social dynamic in the country, and that does have an impact on the way that judges behave and on the way that people who want to be judges think, right? So you may have people coming out of a different environment, a different social environment, and applying to be judges who are thinking about things in ways that they didn't think about them 15, 20 years ago because they weren't part of the popular culture. Question four, who nominates federal judges and who confirms them? Remember, federal judges are nominated by the executive and confirmed by the Senate. Federal judges are part of the federal system, and their boss is the executive. In states, there are different ways of nominating judges. For state court, they might be nominated by governors or confirmed by the judicial commissions. But we're talking about the federal system, and that's the executive and the Senate. Question five. How many Supreme Court justices must vote to take up a petition for cert and agree to hear a case? How many must vote to constitute a majority? Well, the first part of that is it takes four. The answer is C. It takes 4 justices to vote to hear a case, and then 5 out of the 9 would make a majority. And that's because you want to give the minority an opportunity to force the case to be heard, even if they think they might lose, because they would like to have those issues aired at the court and aired in public. Question 6. Which of the circuit courts of appeal is the largest according to our textbook? The ninth, which covers most of the West Coast, is the largest circuit court of appeals. And the first, which is New England, part of New England, is the smallest. Question 7. A lot of you guys got this one wrong. And perhaps we didn't cover it quite enough in class, or in our class shell, in our online distribution of materials. Dispute resolution processes. Litigation is when you file a lawsuit and you go to court and argue. What happens there is you do get binding public decisions. You get verdicts, and they do have precedential value. Self-help is when you have a dispute with somebody and you just go over and deal with it yourself, face to face maybe. if you have a dispute with somebody who dented your car, and you go to their house and you dent their car, or you go to their house and you say, give me some money, and they say, I'm not going to give you some money, and you say, well, you better give me some money or I'm going to light you up on social media, and they give you $200 to get your dent out. That's self-help. I wouldn't recommend it, and it's also um, it doesn't result in a resolution. It just results in people getting madder and madder. Arbitration is a private dispute resolution process, but it is binding. If you are compelled to go to arbitration, your credit card company, you have a dispute there, or you have a dispute with your broker or your cell phone, and you have to go to arbitration, those decisions are binding. It's true that they don't have any precedential value, and that's a big problem with arbitration. In fact, there are some private companies that make arbitration of disputes part of the employment contract. And if you go to those companies and something terrible happens to you, they will try to get you into arbitration so that your case is not public, so it's not in court. Mediation is the right answer here, and mediation is a private dispute resolution process where somebody just sits down with the parties and tries to talk with them to get them to agree to a resolution. And that resolution is not binding. The mediator has no power to make them resolve the case or to make them do what they say they're going to do to resolve the case. It's just a way to try to mediate the dispute so that the parties will agree on how to resolve it amongst themselves. Question 8, true or false? State court structures are largely the same. That's false. State court structures differ from state to state. Some of them are really simple. They have trial courts, maybe one level appellate court and one Supreme Court. Some of them are very complicated. They may have multiple levels of trial courts. They may have different kinds of appellate courts. Things may go up and down. There were some diagrams in our casebook, and there were some sections of our casebook that talked about how state court structures are very different, and that makes it hard when you're from out of state to go into a state you don't know that well and navigate that state court system. That's why you always want to get a local lawyer, and that's why, frankly, in a lot of states you got to be admitted to the bar of that state to practice law there, because then you know about the structures. Question 9, true or false? Advancing a shared understanding of the law is a major public policy purpose of an appellate court system. That's true. The appellate courts exist to make us all understand how the law applies to all of us. The appellate courts issue rulings that shape policy and shift things, and the idea that we all as a nation understand what the rules are is part of what appellate courts do. Question 10, true or false? Personal charisma is a useful attribute for an appellate specialist to possess because it may help them appeal to a jury. A lot of you guys got this one wrong. What's the key word? The key word is jury. Usually at the appellate level, in fact, almost always at the appellate level, there are no juries at the appellate level. When you are in a trial court, you have a jury. But when that case goes to appeal, those appeals are heard by a panel of judges, not by a jury. So there are no juries at the appellate level, and therefore personal charisma, while it might be useful for a variety of things, isn't going to help you with a jury on appeal. Question 12, true or false? The U.S. Supreme Court requires justices to take quasi-retirement at 80. That's false. When you are appointed to the Supreme Court, it is a lifetime appointment. That means you are there, or that you can stay there until you die, unless you're impeached. But impeachment is very, very hard at the Supreme Court level, really at any level. So if you are on the Supreme Court, you're there until you die. And that's what happened with Ruth Bader Ginsburg. Ruth Bader Ginsburg was trying to hold on until after the election, hoping that Joe Biden would win and Donald Trump would lose, and then Joe Biden would nominate her replacement. But she couldn't, and she died. You do not have to retire if you're a Supreme Court justice. You can choose to, but you don't have to. Question 12, true or false? All 9 Supreme Court justices attend law school at Harvard or Yale. That was true, but is no longer true because Amy Coney Barrett was appointed, and she went to Notre Dame Law School. So it is not true right now. Question 13, true or false? A president can and has become a Supreme Court justice after leaving office. That is true. It's happened once. Could it happen again? You never know. I mean, it would be pretty crazy, but you could imagine Joe Biden nominating Barack Obama maybe or you could imagine, all kinds of strange things happening. It has happened and it can happen. All right, I'm going to stop here and I'm going to do another one for these short answers.